All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Morning and welcome to the Kansas Supreme Court courtroom, as well as to our live stream for those who may be watching that way. We have a revised docket this week that has changed on relatively short notice in memory of retired Justice Fred Six, who passed away last week and whose service is tomorrow. The court will be in recess tomorrow, and so I know that this doesn't really impact the first morning schedule, but do want to just let people who are listening and planning to listen tomorrow even to know that those cases have all been moved to this afternoon. So just to be aware of that scheduling and docket change. Before we begin, I would like to say a little bit about the procedures that we will follow today. The court has received briefs from the parties, written arguments that they have presented. All of our morning cases are cases that have come through the Court of Appeals. So we have also reviewed the Court of Appeals decision and documents that arise from that, the petition for review and other things, as well as parts of the record and other matters. We have done our independent research, our own work. So we will be looking at computers and notes to help refresh our memories of things that we have made notes about. Please know that when we do that, we are still very much engaged in listening to the arguments of counsel, but are just checking something as we're doing so. So with that, I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Your Honor. First case on the 9 a.m. docket for Wednesday, May 8th, 2024 is appeal number 125274, Rodney L. Ross and Tonda R. Ross. Rodney L. Ross as trustee of the Carol J. Ross Revocable Trust, Rodney L. Ross as trustee of the Maynard O. Rose Revocable Trust, and Laura E. Field Trust as trustee of the Laura E. Fields Trust Number 1 Appalese versus Norman Terry Nelson, Stillwater Swine LLC, Husky Hogs LLC, and NTN LP. Appellants, Phillips County. Briefs both sides.
May it please the court, Patrick Hughes on behalf of Norman Terry Nelson, Stillwater Swine LLC, Husky Hogs LLC, and NTN LP, present and ready for argument. I'd request 5 minutes for rebuttal.
5 minutes is granted. Thank you.
If it please the court, my name is Randy Rathrum from Wichita. I represent the plaintiffs, Mr. and Mrs. Ross and their entities, and Ms. Field and her entity. We are present and ready for argument.
Second case is appeal number 124442, State of Kansas versus Mark Edward Baldwin, Jackson County. Briefs both sides.
Madam Chief Justice, and may it please the court, I'm James Ladd of the Appellate Defender's Office. I represent Mark Baldwin. I'm ready for argument, and Madam Chief Justice, may I please request 3 minutes for rebuttal?
3 minutes is granted.
Thank you.
May it please the court, the state appears by Deputy Solicitor General Chris Elsleger, present and ready for argument.
Your Honor, that concludes the 9 a.m. docket.
With that, I will call counsel forward on case number 125274. I'm going to give the abbreviated version of the caption and say Ross versus Nelson. Council.
May it please the court, Patrick Hughes on behalf of the appellants Norman Terry Nelson, Stillwater Swine LLC, Husky Hogs LLC, and NTN LP. The foundational question in this case is, does the body of rights that makes up a highway right-of-way include the right to place a privately owned pipeline in the boundaries of the right-of-way? The amici tell us that Kansas agricultural producers have understood the answer to be yes. In fact, the Supreme Court understood the answer to be yes in 1915 when it wrote in the Murphy case that a person who lays pipelines in the public right-of-way for private purposes should have buried the pipeline in the public right-of-way. To understand why the answer is yes, we have to understand the test that the Kansas Supreme Court has used in the past to determine whether a specific use is within the scope of the rights that the state owns as part of the highway right-of-way.
Let me ask you just as an initial matter, Murphy was a negligence case, right?
That's right.
And so it really didn't address the substantive issue that you're talking about.
Exactly.
Is there a case that you can cite that is more directly on point?
Yes. So we start with the proposition that we're looking at a right that was granted by the federal government under the Mining Act of 1866. And the U.S. Supreme Court tells us that that body of rights includes whatever Kansas says that body of rights included. And so in 1904, it came to the Kansas Supreme Court to ask the question, what does that body of rights include? And the Kansas Supreme Court set out a test that began in the McCain case. And this was a telephone case. And the question was whether putting the telephone poles and lines in the right-of-way.
No, I meant you cited Murphy for the gas company, you know, that it would be not a public utility, so a private.
Right.
Is there a case for a private?
There's not a case that arises in the context of it being a private use. The context in which the cases arise are ones where you have public or a quasi-public utility or something like that.
Okay,
But
thank you.
The reasoning of the cases doesn't stem from that. Instead, in McCain, what the court does is it says that we're going to look at the purpose. It says the purpose of the highway is the controlling factor in answering the question of whether the easement contains the rights needed for a telephone line. It said the question of whether an easement was included the rights for a telephone line must be decided by the scope and purposes of the highway, and whether the issue is a means of travel and transportation. So that's the test that the court announces in 1904. In 1905, the question comes up again, this time as to a pipeline. And the pipeline company in the 1905 case comes to the court and says, we have the right to put the pipeline there because the adjoining landowner gave us permission. And the Supreme Court disagrees, agrees that the pipeline company has the right to put the pipeline there, but disagrees that the source of that right is the permission that the pipeline company has. The court writes that—
Well, let me ask you,
Yes.
what right does the public have in a highway easement? It's a non-possessory interest, right?
the public has the right to use that property for all transportation and communication purposes.
That's a non-possessory right.
It is an easement. The extent to which it is possessory, I think, is an open question.
At least our early case law describes it as such.
Right, and we have other case law that suggests in the context, particularly we're looking at railroad rights of way, right? That we have, and there's an exclusive component of that revolves around safety, and we have the same underlying interest with respect to highways as well. And so there is the ability, we have this the concept of an abutter's right of access and taking access, which means that we can exclude from the right of way, we can exclude the adjoining landowner or anybody else by regulation.
But once that easement has been created, and it's been described that once in McCann, I think, when land is once taken for a public use, it is afterward applied to another similar public use, then no additional compensation is due. I think that's a takings question in that case, but isn't it also suggest that that sort of use is consistent with the scope of the easement?
That's exactly what the court's saying, is that whatever we got, whatever's that scope of the
Right.
use, it's not a new taking, or it's, in this case, it was never went to the landowner. But in any case, that's right, because the scope of the easement is for transportation purposes. Any transportation purpose is allowed without it being a new taking, without it intruding on the rights of the adjoining landowner. And because it doesn't intrude on the rights of the adjoining landowner, we have a standing problem, in this case, if the scope of the rights includes the ability to put in a pipeline for transportation purposes. Because if that were done incorrectly, it would be a wrong against the public, not a wrong against the private landowner.
Is
So-
the second, let me ask you that. So if we reasonably interpret, Kansas case law to say that, this highway easement includes, the use directly related to the purpose of transportation, don't our cases also say that it must serve a public purpose?
Well, in a sense, of course, but when I drive my private car on a road, I don't need to pick up hitchhikers. I'm not required to do that. The public purpose is found in the transportation itself. We're transporting product from one location to another. And that transportation that's an inherent public purpose in the right of way. Now, we have additional public purposes that are served here. For example, in McCann, one of the things the court found that it noted is that you're substituting, instead of messengers, that we have 1,000 messengers a day, now we can have the lesser impact on our roads of telephone lines. Similarly, rather than having 1,000 tanker trucks a year hauling the water and effluent that we have in this case, we have a pipeline that doesn't then require the maintenance and the traffic and the safety hazards that come from all that truck traffic. So there are public purposes in the very exercise of the public right by an individual in the public is a public purpose. We found this in the hunting case, where hunting, of course, is a public right, but even though, and therefore a public purpose, even though it's exercised by an individual.
Okay, so, what you're saying, I see what you're saying. But do you have a case that you can give us in Kansas that says that the public purpose is inherently found in transportation itself, which is what I wrote down that you said?
So what we find, I don't have a case that has those words, no. But what we have is the McCann case that tells us that we're looking at the purpose. And what is the purpose of the easement? It's for transportation and communication. It tells us that that's
McCain or McCann?
I'm sorry, McCann.
Okay, so McCann though was a telephone pole.
That's true, but the reasoning that the court uses isn't, it's a telephone pole. What the court says is, we're going to use the test of what matters is this in accordance with the purpose of transportation or communication. That's the test that
Well,
they're
that's the
using.
first part of it, but in, telephone poles, those are public utilities, they're not for profit, for private profit.
That's true, and neither is my car. And so, and there's no statute that gives me the right to use the road for my car.
But-
Instead, there are statutes that regulate how that right is used.
But me driving my car, I don't make a profit off of that.
Well, I might operate it from my business, and I might be hauling, and certainly if I have a tanker truck that I'm hauling my water and my effluent with,
Yeah.
I'm using it in my business. And that is as a sufficient public purpose because it is the exercise of a public right by a member of the public. That's why we have public rights, is for the individuals in the public. And so we can look at section 20 of the Kansas Bill of Rights, and we see that the rights are reserved to the people. So, and we see this carried out then in the case that deals with ice on the Kansas River. The Kansas Supreme Court faces the question of who gets to take it. And the Kansas Supreme Court says that until the legislature creates some rules about it, it's a public right, and so anybody can take it. It's inherent, the use of that ice for the public use is inherent in every individual.
Which leads me to the question of where would we draw the line?
But you don't. The regular
So
legislature.
if 100 people wanted to do what your client did,
Yes, then if there's a problem, then this is a regulatory problem. It's a traffic problem. The nature of traffic is you have more demand then you have ability, capacity to service that demand. And the legislature's role then, just as ice on the Kansas River, if it's a problem, to create the regulatory environment to distribute those rights or allocate those rights among the competing interests.
But you're
Can I-
analogy,
Oh, go ahead if you have a question on this issue. I do have a couple questions on the nuisance issue.
You're analogizing your truck to the road, correct? Or you're analogizing the pipe to a truck on the road,
Yes,
not the road.
that is correct. The pipe is a vehicle for the transportation of the commodity inside the vehicle.
But if that analogy is correct, then aren't you saying it's okay if you're the only truck that's allowed on the road?
I'm saying the legislature can decide how to deal with traffic. It's certainly true that when there is a competition, well, again, the ice case, what the result of that is only one person gets to take the ice. And the Kansas Supreme Court says, if the legislature wants to change that, they can. And that is a legislative decision, because that is a potential problem. If we have more demand than we have space in the right of way, then something's going to need to be done to allocate those rights. And what's to be done is not to say, well, as a matter of law, it's not included within that body of rights. The question is, how do we regulate those public rights? How do we regulate the right for hunting? Not everybody can hunt because there's not enough wildlife. We regulate that at the legislative level. We don't say, because there's not enough for everybody to use that public right, nobody can. And so it becomes a question of regulation. But what we're looking at today is the question of, is it within the scope of the rights that were acquired from the federal government when the federal government made that gift to the people of Kansas?
and here, some of that regulation comes through the local permitting process.
Well, no, the local permitting process here is really it's some regulation. It's regulation in the sense of some of the requirements for the pipe itself. It's not a process, though, here where the county commission approves or disapproves. There's no discretion in it. It's really kind of a registration, and you meet these standards for the pipeline. And then you're not in violation of our regulations.
And even if they were, would that still be outside the bounds of trespass? It would
Yes,
be something-
because then it's not a right that belongs to the adjoining landowner. If I drive my car when it's not registered on the roadway, I don't suddenly commit trespass. Instead, what I've done is violated the public's rights. If I drop a hay bale out of the back of my truck onto the highway while I'm driving, I have not trespassed on the adjoining landowner by doing that. I've impaired the public's rights to travel by doing that. So it's not a trespass case.
So in your view, there's nothing that stops 10 landowners in the area of putting in pipeline on that easement?
Practically there is, because there's no
Right.
need, but until that traffic problem becomes a problem, there's nothing that stops that. The legislature can step in, or through the county commission, which has home rule power, can step in when and if those kinds of conflicts arise, and by regulation control those conflicts. But it isn't a question of what the scope of the right that the public owns. It's a question of how that body of rights is allowed to be used and how it's regulated.
Okay, if I can move you on to nuisance now. As I read the summary judgment ruling, the district court decided on summary judgment that your clients were not entitled to judgment as a matter of law because the summary judgment evidence didn't establish the compliance with law presumption, which triggers the good agricultural practices presumption, which means then it's not a nuisance. It's presumed not to be a nuisance. Then at trial, that issue's not renewed. And typically we require unless it's just a pure question of fact, that issue to be renewed on summary judgment, given the interlocutory nature of a summary judgment ruling. Am I reading the record correct there? And what's your best argument for why this issue is even properly before us?
There are two nuisance issues. One is the Dill case, which would support the argument that there wasn't sufficient evidence, and that's completely separate from the
Yeah,
question we're looking at in the statute.
Yeah, I'm
Right.
focusing on the statutory
Right.
defense.
And as to the statute, the denial of the motion for summary judgment became a final order when the verdict is entered and the judgment is entered based on the verdict. And then once that becomes a final order, the interlocutory orders of the court become appealable. And so we're able to go back to that question that the district court decided on the motion for summary judgment and review that question because that interlocutory order has become final.
But the interlocutory order was simply that there's a fact question.
The interlocutory order went beyond that. It wasn't a fact question. It was it was a legal conclusion. The legal conclusion was that it was because you have a trespass, you cannot use the statute. That was a legal question. It wasn't a factual question in that sense where there's a contested fact. The conclusion was because we've determined that it was a trespass, you didn't follow the law. Because you didn't follow the law, you can't trigger the presumption. So that was entirely a legal analysis, not a factual analysis.
Okay. So you're suggesting that that ruling was essentially purely a legal conclusion.
Right. That's what the court indicates, is that it is the conclusion that there's a trespass that prevents the statute from operating to create this protection.
And there was no indication that you could have brought new evidence at trial to demonstrate compliance with the law?
Well, you couldn't, in the sense of the court has decided as a matter of law.
Enter judgment on the
And so
trespass.
once that judgment is entered, the court is saying it automatically flows from that you cannot possibly establish the application of the statute because the trespass prevents the application of the statute.
So that barred you from asserting that presumption, not necessarily from otherwise proving it was a good agricultural practice, but in terms of that statutory presumption in subsection B.
That's correct. That's correct.
Please, the court, Randy Rathman, I represent Mr. and Mrs. Ross and their entities, and Laura Field and her entity, her trust. I don't want to start out and talk about a case right off the bat because I think the court needs to understand the enormity of what happened in this case. I have to take you back, if I could, to the Monday afternoon, August the 21st of 2017. My client was out doing something that all farmers like to do, going out and checking the field. He comes up over a hill, and as he looks down the hill, there is an excavator tearing out all of his fences and tearing out his trees. And so he drives up and says, "What in the world is going on here?" He calls his county commissioner. The county commissioner arrives. Mr. Nelson arrives about the same time. They say, "Where is your permit?" And Mr. Nelson says, "I don't need a permit. I've done it before. I'll do it again, and you can't stop me." And that's their view of the law. And in this case, we didn't stop him. He went on ahead and finished in spite of the sheriff's orders. So that brings us here today. Now, one thing that's not been discussed, and I think real important, is the statute that back a year before the Beckwith case, which I think is the key case, but a year after the Beckwith case. In 1874, in the Session Laws 111, Section 1, the legislature said all section lines in Norton County will be public highways if 10 freeholders ask for that permission. And so we were dealing here with a public highway that was created by an act of the legislature. Now, the year before that, in the case that controls this whole thing, I believe, Shawnee County had taken property from a man by the name of Mr. Beckwith and didn't want to pay him for it. And this court looked at that issue back in 1874, and that opinion has been cited innumerable times, clear up until I think the last one was in 235 Can in the Southwest Bell versus KCC case. It's been cited innumerable times for when there is a taking of this nature, and I'm not talking about in the city, This is a situation where the legislature took property. This court has said the landowner keeps the fee right up to the road, and the county or whoever maintaining it only gets an easement. That law has been standard law for 140 years. Your Honor, the reason he could not list a case in which a private individual had tried to do this is because there are no cases in which private individuals went out and tried to lay lines like this anywhere.
Just a very basic question to help my ignorance in this area. Are the public highway easements set forth in a kind of meets and bounds kind of a way, such that we could say it extends 75 feet from the edge of the road?
In fact, what happens is the session laws, I believe they say it has to be a reasonable amount of property when they take the property from the landowners. And so there's no specific amount, although the court in Beckwith determined that the set off was reasonable. But I know of no statutory that
So
says.
in other words, with respect to this particular easement, you can't go to the county register of deeds and pull a meets and bounds description of the easement.
This is an act of the legislature saying all section lines are public highways.
And since you started out describing what actually happened, do you know how, what was the distance between the road and the fence and tree line?
I would
Is that in the
say,
record?
it's on the record, but I would say from me to you, Your Honor. So at this,
Let me ask a question. When I was reading through everything, is it that the fee goes right up to, I mean, it includes the road, but what Beckwith says is the owners of real property that include public highways retain fee title and have the right to use that land as long as it doesn't interfere with the use of the road. So it actually includes the highway, but they just can't interfere with it, or?
Your Honor, I've thought about that, and it may be similar to you owe to the middle of the river. I mean, but certainly the private individual, the abutting landowner can't do anything to interfere with traffic up because the laws are playing on that. But Beckwith also says we can't interfere with abutting landowner's grass, trees, whatever he wants to do in that ditch. And this has been good law for 140 years. There are three ways you can do a pipeline.
Didn't mean to interrupt. The flip of Justice Steele's question then in your exchange leaves me confused about whether or not the property owner's title, indicates where the property ends.
I think it clearly says up to the road. That's what the cases say.
But
And it says, and Beckwith specifically says the ditches are the property of, the ditches are fee.
But if you were to look at the deed, would it describe the boundary of the property as the section line?
I
I
can't,
think that's.
I
the
don't
Chief
know.
Justice.
I don't know. I'm sorry about that. There are three ways I think you can lay a line.
Part of the reason that may become important is, does that property owner own underneath the easement?
I don't know. The
Which may
property
be-
owner has all the rights with fee, and of course, all the rights of fee includes the subsurface rights. Because the abutting property owner has a fee interest right up to the road. And he can't do any, in fact, he's probably got a fee interest under the road, but he can't do anything to interfere with travel on the road.
Well, and isn't that sort of accurate with our description of the case law, how it's been described, is the fee owner owns everything, including the road and subsurface, but that they're limited to, they can't use it in a way that interferes with the easement.
I haven't seen anything anywhere that says the abutting landowners own the road as well because they have a fee underneath it. I mean, that's certainly a conclusion that could be drawn, but I'm not aware of
Maybe,
any.
yeah,
cases
maybe
that say
more
that.
legal treatise than case law.
So I see three ways that you can do this. You can do it with consent of adjoining landowner, you can do it with legislation, or you can do it if you're a public utility. Clearly, he was not any of these. This court has cited Beckwith so many times, and in fact, if you look at this, all the people that quarrel with the defendant's argument is all those cases, two AG's opinions, the district court, a unanimous court of appeals, and maybe most importantly, Mr. Hughes himself, when he was testifying about legislation, whose attempt was to set this judgment aside. Mr. Hughes testified in front of the legislature, you know, the trial court is right and the remedy is not in the law. Now, I don't think judicial estoppel probably applies to that because I don't think you meet all the elements of judicial estoppel, but certainly when he's in front of the legislature telling the legislature that the trial court was right and the remedy is with the legislation, I don't know, there should be some estoppel there.
Does the Murphy gas and oil case disrupt your narrative of what the law says? I mean, because it's a private purpose case, right?
I don't see how, because it had nothing to do with transport. I don't see how it does, Your.
Well, why not, when what you described are, you said there's three ways. And Murphy is a fourth way. I mean, it's a private company and the case says for private purposes.
Your Honor, I'm not sure that I understand the purpose in Murphy was for a private purpose.
Would you acknowledge that the court described it as a private purpose?
Your Honor, you're familiar with it, and so I'm probably going to, but
Yeah, I'm just
but
asking you to
I don't.
account for that decision, or is it just an aberration that we should disapprove?
It's the only, I don't see any cases that have been cited in this that says a private entity for private purposes can lay their line without consent of an abutting landowner. It's
Wasn't the pipe obstructing traffic?
sorry?
The Murphy pipe, wasn't it obstructing traffic? Wasn't that the problem why it was a negligence case?
Well, I don't think, I didn't notice it. I thought it was a matter of the collision with the pipe.
Yeah, I mean, I don't have the case in front of me, but colloquially, the conclusion was sort of, you should have buried the pipe.
And of course, that whole case is out of context for this, and it didn't deal with the easement and the fee and who owns that. But I certainly think the context is important in this case, Your Honor.
So a private company could have buried the pipe if they'd gotten permission from the landowner to do it, right?
Absolutely. Absolutely. And in fact, that's what's happened over the years. I mean, it's not, people just don't go out and dig up ditches and put pipes down there unless they've got permission or they've talked to the county. In this case, the county had specifically not given a permit. He had not got permission, and his position was, I can do it because I want to do it. And what's to stop the next guy from saying, I can do it because I want to do it? There's nothing. The Association of Counties say this isn't in, when they responded to this legislation that the defendant suggested, they said, we don't want that job. That's not our job. I mean, this is going to be, how many private lines can you put in a ditch that you have no legal interest in and that interferes with my client's fee? I just don't know how you do it without an act from the legislature. So, Your Honor, I want to quickly scoot over to the nuisance issue. To me, it was a Judge Klein case down from Wichita, and I'm a little bit familiar with it. And, you know, in these situations, they were trying to permanently enjoin an operation. And the Supreme Court just said, you know, I think the way to analyze that is there's an adequate remedy at law. And if there's an adequate remedy of law, suing for a nuisance, you can't get permanent injunctive relief. And that's what Dill was doing, permanent injunctive relief. Now, there might be some question about whether that's even good case law after the Right to Farm Act. And I don't know, I cannot see how you distinguish what's happened here on the right to farm situation. What we have here, because, well, a couple of things. As the Court of Appeals noted, they didn't even bring up, they've never argued C2 that this was a reasonable expansion. That's never even been argued. It wasn't argued down below. And so there's never been any argument that this was a reasonable expansion. My client and his family have lived on that property since 1963. They were there long before the situation, and that's the introductory language under the Right to Freedom to Farm Act. They were there making use. The center pivot irrigations weren't put in until the last 20 years or so. And so they've lived there long before the center pivot irrigations. And here is the key, I think, on the freedom to farm. You cannot run that pig operation without a way to dispose of the waste. The center pivots are essential. You can't have an existing pig operation without a way in which you've convinced KDHE that we're going to dispose of all of our waste. So the pipeline was essential to have the hog operation. There's no way around that. And so,
Well, why are we even considering upstream activities in terms of the nuisance? The statute, subsection A, it provides a defense against nuisance for, quote, agricultural activities conducted on farmland. Subsection B, which then gets into the compliance with the law, says if such agricultural activity, referring back to subsection A, activity on the farmland. So why does the statute allow us to even look back in terms of whether or not the activity complies with the law to any conduct that's not strictly on the farm ground?
yeah, I don't know that the statute limits it to that. And I think you have to look back, Your Honor, because the whole thing is run through one. The center pivots are only there to get rid of the manure from the, I mean, obviously they can put water out.
Well, how do we get there under that language that said that I just quoted to you on the farmland? Activities conducted on farmland.
In section A.
Yeah, and then section B says such activities, if conformity with the law is presumed to be a good agricultural practice.
And if you look at the definition of activities, I mean, isn't spraying liquefied pig manure an activity on that farm property?
I agree. It is an activity on the farmland, but the question is whether that activity complied with the law, the spraying on the farmland. And I'm just wondering, under that statute, is there an interpretation that allows us to expand our focus to that upstream conduct that gets you to the farm ground?
One, I don't think you have to. And number two, the court's analysis was, when you talk about existing laws, rules, regulations, this court has always said that existing law also includes case law, common law. And in this case, there was common law that said what he was doing was a trespass. And so, I mean, therefore, he's not conducting that activity consistent with good agricultural practices.
Let me ask you a question. So what you have is, from one activity on farmland, and then you have the pipeline that's not on farmland, and then it's going to farmland, right? Okay. And so the question is that the illegal activity seems to be happening in the pipeline and not on the farmland or the farmland.
Well, here's the problem. You can't get to the farmland without the illegal activity. If you, every day when you are running liquefied hog manure down the ditch, that is a legal activity. You can't get to the other activity without having an illegality every day.
What if they drove it on the highway and then pumped it into, or used the pump to get it into the pivot?
Then there's a different issue. Then you have to look at the issue and see whether you're going to qualify for the way they actually sprayed it on my client's property, whether that's good farming practices. But we didn't even need to get to that because there clearly was an illegal activity that was part of this activity. One thing that, look at it this way, if we load up all that hog manure at the end of every day and drive to the property to dispose of it as opposed to running it through the pipeline. But let's say there's a big hole in the side of our truck or in our tanker and it leaks pig manure all the way to the other place where you're disposing of it. That is a trespass, dumping your pig manure on public roads. No one would say the Right to Farm Act allows that. The farmer couldn't say, well, under the Freedom to Farm Act, I can spread this wherever I want because it's not a nuisance. And maybe it isn't a nuisance, but it's certainly a trespass. And you can't find protection in the Freedom to Farm Act there.
Please, the court, I'd like to begin by supplementing an answer that I gave previously to make it more complete. The question dealt with whether I could point to a case in which we were dealing with private rights in the use of the road right-of-way. And I neglected to mention the case that I cited in the brief of Walker versus Armstrong from 1863, in which the court held that all persons had the right to land a ferry boat at the mouth of the public highway without the consent of the owner of the soil until the legislature granted an exclusive franchise for doing that. The underlying principle there being that anyone could use that as an individual here for the landing of a ferry boat. With that said, there are a few comments that I'd like to respond to briefly with respect to the facts of the case. And that would be the tearing out of the fences allegation, the allegation that Terry Nelson said, you can't stop me, the claim that he hadn't gotten permission. I think in all of those things, as you review the factual record, you'll see that that's not a complete description of what it is that happened, and that maybe you may find that is in fact a misleading one. But it doesn't matter to the legal issues that we're dealing with. To the extent that this is a case of first impression, we are of course in exactly the right court to deal with that. And so to the extent that we don't have a case that says specifically you can do this, we come to you to say, should we apply the same rule we've always applied?
So on that point, on that very point, I wanted to dig in a little bit to what you said at the beginning of your rebuttal. I think you were describing case law that relates to rivers and ferries. Is that correct? And then earlier you talked about ice on a river.
Right.
The difference here might be, well, it is a difference and it might matter legally, that when we deal with the public right of way in rivers, we don't have an easement. Whereas with roads, we do. Does that matter?
I think that the rule is that for a navigable river, the water, of course, belongs to the public and the public has the right to use it, but to the center of the river, the landowner owns the fee to the center of the river, much like with the road right of way. And with the road right of way, in answer to the earlier question.
You would agree with me that there's no easement.
There is an easement. It is because that's what the public right is with respect to, it owns both the water and the right to use the area.
How does the easement come into existence? I mean, maybe I'm just dead wrong on this, but when the public takes land for a public highway,
right,
I mean, they obtain an easement.
Well, when the public obtains land for a highway when they want to obtain a right of way, that's what they obtain. Here, there's no question that what they got from the federal government was a right of way, wasn't merely an easement. That's true. And so the question is, the body of rights that were used, were those rights that were conveyed to the plaintiffs' predecessors in interest? Or were those rights that had been conveyed already to the people of Kansas?
I'm just trying to figure out if the application of the river cases is a square four-leg application, because I don't understand how there's an easement in those cases.
The point of the river case is that we're dealing with a right that belongs to the public at large. And the question
is, it's a feature of geography. I mean, that's public waterway law strikes me as quite different from
But the underlying principle, and the same principle with hunting, is that we have a right that belongs to the public at large. And the question is, who can use that right? And the answer is the individual members of the public. So the question, what it doesn't answer is the question of, is there a distinction between a pipeline, a legal distinction, between a pipeline that serves several people or two people and a pipeline that serves one person? And if so, where do we find that legal distinction? What's the basis for saying?
What if I had two pieces of property on opposite sides of a highway separated by a mile? And I was an exotic billionaire and I just wanted to be able to move back and forth. Could I build a tunnel under the highway?
You could not do that because that is a transportation use that has been acquired by the public. And so you couldn't do that.
Why not?
Because that's not within the body of rights that were retained. The body of rights that were retained were everything but the right for transportation purposes. Now, could you
That's
do?
transportation.
Well, I'm sorry. What I meant to say is you could not do that as the owner because you're the owner. You could do that because it's a transportation purpose. You would be using the public right. You wouldn't be using your retained rights as.
Yeah, so the
owner.
answer is I could. do
Yeah,
that.
you could. Yes, you could do
Okay.
that as part of the road right of way, right? Yes, yes. And so we have this question then of why would we make a distinction between two people using the pipeline and one person using the pipeline? And the courts below get kind of trapped in this idea of public use and then kind of mixing up public use in different contexts that it appears. Public use is important for roads because for all public rights, the only power that the state has to take private property is for a public use. But that does not mean that every member of that only for public utilities. Public utilities have two rights when they place pipelines. They have the right that they pay for by eminent domain, and they have the right that they share with every other member of the public to use the road right of way. If the right to place a pipeline is not in that scope of rights of the road right of way, then they ought to be having to pay for it, just as they do when they put their pipeline anywhere else.
But
But
aren't you just swallowing up the whole meaning of public use?
No, because because the public use requirement, no more than we swallow up the meaning of public use when I allow a public entity to condemn land that it then uses for a parking lot that serves a development that has a public purpose. The legislature has recently said, we're not going to allow those kinds of uses of eminent domain, but the courts didn't say that. Instead, we need to find a nexus to the public. And we have a nexus to the public because of transportation. We have a nexus to the public because of the fact that it reduces traffic. We have a nexus to the public interest because it allows for the recycling and efficient use of water. We have a nexus to the public interest because it allows for agriculture in Kansas to remain competitive and efficient. All of these things are reasons that justify allowing a pipeline in the public right of way. And
Aren't those all questions of fact, though?
no, the question is whether the pipeline easement contains the right for a pipeline for private purposes. And it certainly does, because a pipeline for private purposes by its very nature is transportation. By its very nature, it's taking cargo and moving it just as you would with a truck. And by its very nature, when it makes that subterranean, it's reducing the traffic, just like the telephone pole reduces the number of messengers that need to go down the public highway.
But doesn't a truck that never leaves impede traffic?
Well, it depends. A truck that's out of the way doesn't. And that's the question. What we can't do is we can't impede traffic. If we do, it's not that we're violating the neighbor's rights, but certainly the public can say, you can't do that. You are abusing the right of way because you're blocking traffic. We're not blocking traffic. There's no one who cannot pass through that road because the pipeline is there. And again, if what we end up with is more people want pipelines, then there is space to accommodate them. That is traffic regulation. That's what we do with then why we have traffic lights, why we have restricted access highways, ways of imposing regulations to better deal with the multiple demands on a limited resource. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. What I mean by that is that the court will next confer about this case. We will discuss the various issues. Hopefully, after that discussion, have a path forward in terms of who will be the authoring justice and how that may shake out. The drafts of the decision, or if there's disagreement about the issues, multiple decisions, there could be a concurring decision. If some of us agree with the outcome but disagree with the reasoning to get to that outcome, or there could be dissents if some of us disagree with the outcome. So those various decisions will be circulated with all of us reviewing, editing, commenting, and after that process is completed, the decision will be filed. Once filed, which we do on Friday mornings, there will be an announcement on the publicly of the filing, and that decision will then be available on the kscourts.org website. Anyone can read that decision at that site, which will also link back to this argument if they're curious to go back and watch the argument again. Thank you, counsel. We'll now call 124-442, State of Kansas versus Mark Edward Baldwin.
Hey, please the court. I'm James Latta of the Appellate Defender's Office. Again, I'm representing Mark Baldwin. We're here today on a narrow issue of what the state has to prove in order to prove that a substance or a substance is alleged to be marijuana is actually marijuana. And I've actually been raising this issue since before the legislature legalized industrial hemp. And I still think I was right before the legislature legalized industrial hemp. Every time I raise this issue, I'm taken back to my 5th grade class here in Avondale West, here in Topeka, Kansas, which closed down. But I'm reminded of my 5th grade teacher, Mrs. Clark. And Mrs. Clark always told her 5th graders, you cannot define a word by using the word itself. And that's what's happening in all these marijuana cases. State of Kansas is saying, this is marijuana because it's marijuana, so it's marijuana. Now, that could work if we were talking about a substance that did not have a definition. But here we have one. And the definition is it came from the cannabis plant. In this case, we have no evidence that the alleged substance came from the cannabis plant. Based on that fact alone, there is insufficient evidence that the substance alleged to be marijuana is in fact marijuana under the legal definition.
Is there any marijuana that doesn't come from the cannabis plant?
I don't know. And
By
that
definition,
I have no idea. I mean, that's why we need.
marijuana is a product derived from the cannabis plant, right?
Correct.
Right. So when you testify that it's marijuana, why isn't that enough to presume that it complies with the statutory definition?
Because why would the legislature define something as itself? The fact that they say marijuana comes from the cannabis plant, just self-evident that it's something different than marijuana, that's what comes from the cannabis plant is different than marijuana itself.
What about Kleenex? Do you have to define Kleenex as a facial paper tissue, or has Kleenex metamorphosized in the English language such as Kleenex?
So I would say, I would give 2 responses. I would say you would still need testimony saying that that what we allege to be Kleenex is actually a paper tissue. And if this court doesn't like that answer, then I would say that Kleenex is much different than plant, drug. I mean, we've had the KBI come in and testify about drugs for decades. I mean, so we're gonna start objecting to the KBI coming in saying this is common knowledge, we don't need them?
Well,
for their
Kroger
expert
might
testimony?
agree with you, but aren't we talking about what the general lay person on a jury would understand?
Sure, and my response would be a lay person on the jury would not know that. Does all marijuana come from the cannabis plant? Could marijuana come from a different plant? I don't know the answer to that. That's why, just because we know some can, maybe all doesn't. We still need we still need.
I thought your
testimony.
argument was the reverse of that. Not that marijuana can come from some other plant, but that things other than marijuana also come from the cannabis plant.
I mean, that's all my argument. My argument is, number one, they have to have testimony that says this substance came from the cannabis plant. Number two, they have to have evidence that says it's not the mature stock, it's not industrial hemp, and it doesn't come from schedules 2 through 5. So it's both. They have to prove both.
Do the exceptions ever apply to a cigarette?
The exceptions?
Exceptions that you just mentioned. We have a cigarette here.
Wait, I'm sorry, what, Your
The
Honor?
cigarette, that's what the officer saw. The blunt or the cigarette, that was a cigarette. Do any of the exceptions apply to cigarette?
I see what you're saying. So you're saying for the fourth exception where it says industrial hemp when possessed or used for activities authorized by the Commercial Industrial Hemp Act is what you're talking about? Okay. Yes, as I have read the Industrial Hemp Act, it's tough to read. I do not read where just possessing by itself industrial hemp is illegal. There is a statute that says distributing and manufacturing industrial hemp cigarettes is illegal. But I cannot find anywhere where it says just having industrial hemp by itself is illegal. So to back up a little bit, Your Honor, in that exception or exemption or whatever we want to call it, it has an or in there. So it says when cultivated, produced, possessed, or used. So my first response would be we have no evidence in here that industrial hemp wasn't initially cultivated or produced for approved purposes. Perhaps there's evidence that it's not possessed or used currently. Then if the court doesn't like that answer, my next answer is just taking away the definition of marijuana itself. The fact that the legislature enacted made a substance called industrial hemp, which has a lower percentage THC. That is a new substance they created. Industrial hemp is not found anywhere in the Controlled Substances Act. Industrial hemp, the THC in industrial hemp is specifically exempted from THC found in Schedule 1. So my argument is reading all the statutes together, as this court has emphasized recently. Whenever somebody possesses a substance and it has below 0.3 THC in it, it's not illegal. We can look at the industrial hemp. I can't find anywhere that says simply possessing it is illegal. It's a new substance found nowhere in the Controlled Substances Act.
So let me
Go ahead.
jump in real quick and just take you back to an evidentiary question. This is based on, your appeal is entirely based on the sufficient evidence, correct?
Yes.
And clearly in the record, the law enforcement testified that he found marijuana cigarettes, correct?
Yes.
Strikes me that your argument is essentially that this is impermissible expert testimony, or this is impermissible testimony because he's not an expert in defining marijuana. Is that fair? It
Well,
requires expert testimony
Sure.
to separate out industrial hemp from illegal marijuana.
Sure, that'd be part of it. I would also add that even with that testimony, we still have insufficient evidence.
Well, why, when he says it's marijuana? I mean, that's evidence
Because,
that it's marijuana.
I mean,
So but my actual follow-up question really was, why doesn't your claim fail because of a lack of objection here?
because my entire argument is even with that evidence, we still have insufficient evidence. He did not testify. To say it's marijuana is not enough because the legislature gave a definition. We do not know that the alleged.
Don't understand that argument at all.
Okay, so
If someone testifies, person A killed person B, they don't need to testify as to the definition, the legal definition of homicide or whatever. That's evidence.
there is no legal definition of homicide is how I distinguish that. If we have oxycodone at issue and the officer testifies.
You're making an argument about expert testimony, not sufficiency. That's how it strikes me. Do
Okay,
you see that distinction?
I understand what you're saying and I disagree.
Okay, fair enough.
I mean, so I do disagree. I think.
Let me piggyback. I'm sorry,
Well,
Chief.
go ahead.
No, on Justice Stiegel's question. What I'm trying to envision in a possession of marijuana case, under your theory, what would need to be produced as evidence and how would that happen? I mean, you have to differentiate the origin of the THC, whether it comes from stock, whether this, or that. How would that functionally happen? And I was thinking along the same lines, are you suggesting then that it would take expert testimony at every possession of marijuana trial to prove that it's marijuana? So tell me how that would
Sure.
work.
So my,
And-
my first response is, we shouldn't worry about how that happens. The legislature said, this is how you prove marijuana. I mean, I remember in Law School 101, when we have a definition, we plug that definition in for the thing. We shouldn't, we seem to be worried anytime we make it harder to get a conviction. I mean, we're
Oh, no,
beyond a
I'm
reasonable
suggesting
doubt.
that. I'm just wondering, what is the burden on the state?
The burden on the state would be to produce evidence that this alleged substance that they're alleging to be marijuana came from the cannabis plant. It's not in Schedules 2 through 5. It's not industrial hemp. And the green vegetative substance is not the mature stalks of the plant. That's the evidence they need to produce. I
And
mean,
that
it's laid out right
becomes-
there for them.
That becomes what the state has to prove only if we accept your argument that that is part of the definition and that those four things are not exceptions that are affirmative defenses. Why didn't that need to be litigated in the trial court? How has this been preserved for?
This court has always said, whenever we're doing insufficiency of evidence,
But how, we are not then talking about sufficiency. That presents to us a question of law about what is the definition. That to me is something different than sufficiency, which we would reach once we've determined that question about that procedural question, that burden of proof question.
sure,
And how can it be fair not to ferret that out at the district court when that burden of proof has to be met?
sure. I suppose I don't really see the difference. I just see my argument as a statutory interpretation, saying that where it says marijuana is not, we're contesting an element, which means it's not an affirmative defense. So the state has to prove it. There was nothing to litigate below. We've done statutory interpretation repeatedly whenever we're doing sufficiency arguments. I mean, that's part of the course. And I would also say that the Court of Appeals reviewed this issue and the state didn't petition anything. So that's also not before this court.
Right, there may be preservation issues both ways, but we see this happening in several cases where things are lumped as a sufficiency argument, but they have embedded within them sub-issues, if you will. And I guess the question becomes, does everything fall under that large, for our standard of review, that large sufficiency question? Or do we have to divide that into those sub-issues and require that some of those sub-issues be
I mean, I
or at
don't,
least discussed under a different standard of review?
I don't see any procedural issues with this. The only sub-issue I see, if you want to call it a sub-issue, is statutory interpretation. The evidence is the evidence. No, if the objections that weren't made, that's what, I have to live with. I don't understand if they would have raised this issue below, we're still at the same place we are now. I've never seen where for sufficiency, they had to make some argument below to preserve it, even if it involves statutory interpretation.
Well, the other recent place where this has happened is on the definition of knife and the arguments about what that means. And one side will take a different position where if this was laid out, the jury could have been instructed. Same thing here, the instructions may have changed. All of those things seem to be, if you're asking for sufficiency, it seems that those things need to be presented to the jury. So here we're not even getting to the point where issues are presented to a jury, and yet we're asking to look into the crystal ball about what a jury did or did not do or might have done.
Sure, my response would be that sufficiency of the evidence, that issue doesn't care about any of that stuff. We have the definition of marijuana that the state has to prove per the legislature. And the state is not doing it, in every marijuana case. And this issue is right before this court. I mean, there could be other issues as well, instructional issues, evidentiary issues. And so That's why I focused on the sufficiency issue, because it's right here, it's before this court. We have all the evidence in the case. Sufficiency doesn't care about objections or what was raised below. We have to look to see if there was sufficient evidence to uphold this conviction. And based on this definition of marijuana, not a definition that I'm trying to bring in, you know, like say dagger. I'm not trying to give a dagger a definition. This is the definition provided by the legislature. This is what the state
So
has.
just to
prove.
be clear, your argument is in every criminal case, when there's an element that has a definition, the state can't just simply refer to the element, the evidence has to go to the definition. So battery, for example, you can't just get somebody on the witness stand to say, you know, committed battery, punched a guy, whatever. You've got to walk through the definition as a matter of evidence.
No, because these cases are different because we're dealing with scientific stuff here, and we're in battery cases. If you say you battered someone, that's both an element and a factual term. We know what you mean. We know you caused physical contact or you caused bodily harm. It's different than saying, I have
So it goes to the technicality of the definition.
Absolutely. That's what makes this different, is this is scientific stuff by nature that the legislature wanted the state to prove. This is the only, I won't say only, one of the few drugs that the legislature actually gave a definition to. And it's a technical definition because drugs are of themselves science-based. I mean, the legislature is basically, I mean, I think it's a fair reading of this to say the legislature wanted the state to present expert testimony in every marijuana case.
Let me just test. I was going to say, let me just test how broadly we should view your argument. So if the state puts on like a KBI lab expert and testifies, I know the definition of marijuana in our state, this was marijuana. And that's the extent of the testimony. Is that sufficient evidence?
Absolutely not. How's the jury ever to decide whether or not it came from the cannabis plant? You have to provide them that opportunity to find for themselves.
I understand that you are arguing these are, the four subparts are not affirmative defenses. And I understand your grammatical the arguments you make about the way that the statute's worded. But I want to focus on whether, what and how we handle situations like this and like a Rose and Brazel, where essentially what the state would have to do under your argument is to prove negative propositions that really are no way for the state to prove. The Brazel case is maybe easier to explain it. There it was, the question was, did he have a prescription for the medication? Well, how is the state ever going to be able to prove that somewhere in all of the pharmacies of the world or all the doctors in the world, a defendant did not have a prescription written?
Sure. So
Why, when the legislature writes in a negative proposition like that, shouldn't we assume that they intend that to be an affirmative defense?
Sure. So I would distinguish your example in Brazel because for the prescriptions, we're moving on to another subsection, which is 215702, which says this act doesn't apply if it's authorized by the Controlled Substance Act, or authorized by law. So I'm going to guess that this court, when it comes to it, is going to read that as an affirmative defense. So for your prescription, whether or not you have a prescription does not contest any of the elements of whether or not someone possessed oxycodone. So I think reading the crime itself, the elements 215702 together, this court will say that's an affirmative defense. Here's the difference though. The legislature specifically said marijuana is not these things. In addition to 215702. To me, so based on the plain language alone, where the legislature said this element is not these things, they wanted the state to disprove them. Number two, it doesn't make sense to me that the state would make two affirmative defenses, 215702, and then also make marijuana is not an affirmative defense. And then finally, I'll point to when the legislature does want to make an affirmative defense, they have explicitly said it. And they explicitly said it in 215706, where they were talking about cannabidiol treatment. They said this is an affirmative defense. When the legislature, we keep worrying about what the state has to prove. You know, the legislature, it's not even the defense. The legislature apparently didn't care. The legislature said marijuana is not these things, therefore you have to disprove them. That's my technical reading of the plain language, and then also reading all the statutes together is why they have to disprove that.
Thank you.
Thank you.
May it please the court, excuse me. Chris Elselager appearing on behalf of the state. I will admit, there were parts of my opposing counsel's argument I couldn't follow for sure. And I'm not sure, it strikes me that his argument would present an impossible burden on the state. I'm not sure what evidence the state could then rely on to prove possession of marijuana. So I want to roll back to, I want to start simple and go back to the laws that exist now. And the under the standard of review for sufficiency of evidence, which is viewing the evidence the light most favorable to the state, could any rational finder of fact, find the defendant guilty. And just as the Court of Appeals found here, that is certainly the case. I mean, we have the evidence from the police officer who visually identified, based on his training and experience, the substance that he found as marijuana. He
Let's
also
just
said he
say,
smelled.
hypothetically, if let's take a different case where what's discovered is like a gummy thing, and a law enforcement officer says, "Well, that's marijuana." I mean, I get that it's like, well, I'm not so sure because this definition is highly technical and there has to be concentrations above certain thresholds, et cetera. And maybe this was to Justice Stiegel's point that maybe that officer isn't qualified to render that sort of opinion in that sort of case. Would you agree with that?
Well, I think there's.
So that different hypothetical, of course, but.
That brings up about three different strands of thought in my head. One is because of the hypothetical, we've changed the facts. Well, maybe the training, that officer in his training experience has never seen a gummy. He can't do that. I don't know.
Right.
Second, it almost comes to like somebody brought up is it's almost like expert testimony. Then, well, that should have some kind of objection from the defendant.
I guess
And then
that's
third,
my point is expert testimony required given the legislature's definition of marijuana?
Not necessarily. I think, and there's case law to that extent, but in this case, we also did have expert testimony. We had the KBI lab chemist who tested and said she found THC, which she testified was the psychoanalytic or element of marijuana. I mean, that's what she said. THC is
but not at the thresholds that trigger the division between, not necessarily, she didn't identify the threshold quantities that necessarily would put it into a prohibited versus a permissible.
Right, but the
category.
defendant didn't challenge that. He didn't object. He didn't say that she didn't meet that threshold. So it stands as it is. She said the THC was what's found in marijuana. And I think based on that, that's sufficient again, coupled with the officer's testimony, plus the context where it was found and how it was found in a cellophane wrapper and rolled up in a little cigarette.
I hate to throw out hypotheticals to you because that's kind of what we're doing here, but what if the testimony was that the THC level in the sample found didn't reach the threshold?
Well, that would certainly be a different situation.
I understand that.
Although
but is that now a substance that's not illegal?
No, I mean, if you have to look at I think it's the Bridget case that said, well, I mean, in that case, they didn't find any THC, but the court looked at the definition of marijuana and said, well, it's not absolutely necessary to find THC. THC is an indicator of marijuana, but it's not required, right? So that's a situation where the state could still say, look, this is marijuana, and I think it would be incumbent upon the defendant to raise, oh, no, wait, that's hemp. If that's what, I mean, as if it was an affirmative defense. And I think that when you look at these exemptions to the definition of marijuana, they really should be treated as affirmative defenses. And I don't agree with his argument that affirmative defenses don't negate an element of the crime because, for example, the mental disease or defect defense is an affirmative defense that only negates the intent element of a specific intent crime. So there's no talismanic language that is required for an affirmative defense. I looked up the definition of affirmative defense in Black's Law Dictionary, and it just says, a defendant's assertion raising new facts and arguments that, if true, will defeat a plaintiff's or prosecution's claim, even if all allegations in the complaint are true. So, yeah, I mean, it's just raising a challenge to the state's case. The state's made its prima facie case, said, look, this has got THC, it's marijuana, it walks like a duck and talks like a duck, so we think it's a duck, and the defendant can say, no, it's not a duck, it's hemp, and here's our proof. Otherwise, to follow his interpretation of the statute would lead, I believe, to an absurd result, because not only is hemp excluded from the definition of marijuana, there's a whole laundry list of things. One of those is, subsection 2 says any substance listed in Schedules 2 through 5 of the Uniform Controlled Substances Act. Now, before this argument, I'd never really looked at the Schedules 2 through 5 of the Uniform Substances Act, but I did. I went to the statutes. Let's see, starting with KSA 654107, and I printed them out, and it is a list. I mean, a laundry list of things. So, by his rationale, not only would the state have to prove this marijuana, we would have to also disprove that it's not raw opium, not opium extracts, not opium fluid, not powdered opium, not granulated opium, not tinctured opium, not codeine, not ethylmorphine, not ectomorphine hydrochloride, not hydrocodone, not hydromorphine, and the list goes on and on and on and on, and that's just Schedule 2. And then we go to Schedule 3, and you can look in the statute books. I mean, it is, I'll use my demonstrative evidence here. I mean, it's just list after list after list. And by his rationale, the state would have to disprove all of that. And then, I don't know, we might also have to disprove that, prove that it's not oregano, it's not parsley, it's not anything. I mean, we have to disprove everything that it could possibly be, and that's not the case law. And if you follow his rationale, that would definitely lead to an absurd result. And we know there's a maximum of statutory interpretation that we avoid absurd results.
We presume that it is marijuana, and we also presume that it has less than the 0.3 level of THC. Also marijuana?
It can be. Again, you go back to the Bridget case where there was no THC found, and that they were able to prove that based on other evidence that it was from the cannabis plant and that it was marijuana. The THC is just an indicator. It tells it tells you that, yeah, this could be marijuana. It's just one indicator, just like the smell that the officer testified to, just like the visual that the officer testified to. It's one thing. It's not the defining thing. It's one thing that helps define marijuana, helps us prove that it's marijuana. Then if it was like only, I don't know, 0.2% or whatever the threshold is, I think then the defendant would have to come back as an affirmative defense and say, look, it doesn't meet the threshold. This was industrial hemp. And he would have to establish that and have to have some kind of evidence of that. And of course, the other element I think that you got to in this is that, industrial hemp is only excluded from the definition of marijuana when it's used for a lawful purpose. And the statute itself on the Commercial Hemp Act defines, let me find the statute number, KSA 2-3908, says that it's unlawful to have cigarettes containing industrial hemp. Also something about, there's somewhere in there also about seeds and
His point is that it's to make, it doesn't use the word possess.
but it still would not be used for lawful purpose, so it wouldn't fall into the exemption of hemp within the definition of marijuana. But regardless, I mean, he can't make the claim that even if it was hemp, that he had it for lawful purpose.
Your position then is that even if it's marijuana, or if it's marijuana, even if it has less than 0.3 THC, it's still an illegal marijuana cigarette?
Potentially. It puts, I think for
Say
the,
potentially, then my immediate reaction is, why have you not proved beyond a reasonable doubt then that he's?
because what I'm saying
violated
is
law?
he has the opportunity to raise as an affirmative defense that it's not marijuana. But under the Bridget case, certainly just because it's below 0.3% or whatever, doesn't mean it's not marijuana. Okay, THC is one indicator. The marijuana could maybe not have as much THC as could be below 3% and still be marijuana. There's other things that make it marijuana. That's what the Bridget case said. You look at did it come from the cannabis plant? So you have to have like a police officer could identify, yes, that's marijuana. I say potentially because of course, with all of this stuff, he has the opportunity to present a defense to disprove it, right? I mean, he has that opportunity to say, no, it fits one of the exceptions. And that's what I guess the crux of the argument is here is that, those exemptions, which have been there, at least the first one has been there since 1977 in the Luganville case when this kind of first came up. Those have always been there and they should be treated as an affirmative defense rather than something the state has to disprove. Since Luganville, no court has ever said that the state has to disprove this whole laundry list of things to also prove this marijuana. The state proves it's marijuana by meeting the first part of the definition. And then once the state has made its prima facie case, well, then it's incumbent upon the defendant. If he wants to say it's one of those exemptions, he has to raise that as an affirmative defense. So then he could argue that, look, it's not, it's below the threshold, it's industrial hemp. And ultimately that might become a question for the jury, but it doesn't, that cutoff it's not a hard rule that says if it's above this cutoff, it is marijuana. If it's below this cutoff, it's not. That's just an indicator. And if it's below that threshold, it could be industrial hemp, but that's a question then for the jury. That's a burden that the defendant would have to prove as an affirmative defense, and the jury would have to make that decision. It's not a, it's kind of like, a DUI, we have this, if you blow, what is it, 0.08, you're over the legal limit and it's kind of, you're driving under the influence. But you know what? Even if you're under that, you could still be, at least in theory, convicted of driving under the influence. If you're 0.07, but you still can't drive, if you're crashing into cars, whatever, you fail a field sobriety test, you could still be convicted of driving under the influence. In fact, you don't have to have the breath test, right? I mean, just based on the field sobriety test and observations of the police officers and so on, you could convict somebody of DUI. Same thing here. I mean, yeah, the THC level, it is a definite indicator. It's evidence, but it's not the end all be all, right? That was, I think, the import of the Pritchett case. And I think in this case, the Court of Appeals adequately, synthesized both Luganville and Pritchett and other case law saying, basically, yeah, that's THC level is evidence, but it's not the only evidence. And these exemptions that are in the definition and the statute defining marijuana are akin to affirmative defenses. I think the reasoning of the Court of Appeals was spot on. It was logical, sensible, and would not lead to absurd results, which is what would happen if you went with my opposing counsel's theory. And so I would ask the court to affirm the Court of Appeals, find that the evidence was sufficient in this case. Thank you.
How do you reserve 3 minutes?
May it please the court. The one main point I want to drive home is so we have science and then we have the law. And under the law of Kansas, THC is absolutely not an indicator that a substance is marijuana. THC is not found in the definition. Even if you prove that it has more than the 0.3 threshold, all you're proving is it's not industrial hemp. You still have to prove it comes from the cannabis plant. So I just want to make that clear. And unless there's any other questions, I'll rest on my briefs.
I'm just still struggling with your argument about why the officer's testimony that this was marijuana just doesn't stop. It is just a hard stop on everything. Because as I understood you to say, that is because marijuana does not include using the statutory language. But if the officer said it's marijuana, then that incorporates anything that would come into making it meet the definition of marijuana. And so we have an affirmative statement on the record, may be wrong, may not have been under the analysis, but it's still there that went to the jury that this is marijuana.
Sure. So I respectfully disagree that when we have a definition, you can no longer say that a substance it's just like Mrs. Clark in 5th grade. When they provide us a definition, we can no longer say a substance is a substance because it's a substance. Your example would work for every other substance in the Controlled Substances Act that has no definition. Once they provide that definition, simply saying something is marijuana does not mean it's marijuana any longer. I disagree that testimony that something is marijuana by itself just saying, if they just say, based on my training and experience, this substance, alleged to be marijuana is marijuana, does not satisfy that because we have no idea what they're basing that on. If there was other testimony that said, my training and experience is that substances from the cannabis plant are marijuana,
But what if the
Mm.
first question had been, do you know the legal definition of marijuana? Yes, I do. What did you find in the defendant's pocket? I found a marijuana cigarette. You're saying that would completely change your argument?
if they testified what they knew the definition of marijuana to be, then we have evidence.
That's what I just asked. If the counsel says, do you know the legal definition? The officer says yes, and gets followed up with, I mean, wouldn't that utterly erase your argument?
So I disagree a little bit. I think we still need to have evidence, a nexus between what they think the definition is and what the actual definition is.
Those are just evidentiary questions, sorry.
Exactly.
I agree. I mean, maybe I'm getting off course here, but in this case, we have no evidence, no testimony, whether proper testimony or improper, about what the alleged marijuana, what plant it came from. And that's my argument, is that because the legislature provided definition, that ends the case, and there's insufficient evidence. I mean, that's in the simplest terms I can put it in, that's my argument. If there's no other questions, I just ask this court to reverse on insufficient evidence, please. Thank you, Your Honor.
Thank you to both counsel. The court will take this matter under advisement. The court will be in recess for 15 minutes until